95% of criminal cases never reach a jury. The constitutional right you were promised barely exists. And what replaced it might be the biggest threat to justice in America. Here is a number that should terrify you. In federal court, 97.6% of convictions come from guilty pleas. State courts hover around 94%. The jury trial, the cornerstone of American justice, has become a relic. But here is what nobody explains. This did not happen by accident. Over decades, a system evolved where going to trial became so dangerous, so risky, that even innocent people choose to plead guilty. And the question you should be asking is not why so many plead guilty. The real question is what happens to those who dare to demand their constitutional right to a trial. The answer reveals something deeply broken in how justice actually works in America today. To understand how we got here, you need to understand the trial penalty. When a defendant rejects a plea offer and loses at trial, they typically receive a sentence 3 to 10 times longer than what prosecutors originally offered. Think about that math. A prosecutor offers 2 years. You believe you are innocent. You demand your day in court. You lose. Now you face 20 years. If this is already making you uncomfortable, drop a like because it gets worse. This is not theoretical. Exposed by the National Association of Criminal Defense Lawyers, the trial penalty operates as punishment for exercising constitutional rights. Defense attorneys call it coercion dressed in legal language. Prosecutors call it rewarding cooperation. But whatever you call it, the effect is undeniable. It makes demanding a trial an act of courage most cannot afford. But let me show you this from a different angle. Imagine you are a public defender. You have 190 active cases. Each client deserves investigation, motions, and trial preparation. The American Bar Association says you should handle no more than 150 felonies per year. You have exceeded that by February. Now a prosecutor with fewer cases, better resources, and more experience offers your client a deal. You know the evidence is weak. You believe you could win. But if you lose, your client faces decades in prison instead of months. And you have 189 other clients waiting. What do you tell them? This is not about lazy lawyers or corrupt judges. This is about a system mathematically designed to avoid trials entirely. The consequences of this system extend far beyond individual cases. The Innocence Project has documented hundreds of cases where innocent people pleaded guilty to crimes they did not commit. Not because they were stupid. Not because they did not understand their rights. Because the alternative was gambling their entire lives on a system stacked against them. Consider this carefully. If 95% of cases end in pleas, it means judges rarely evaluate evidence. Juries rarely deliberate. The constitutional promise of being judged by your peers has become a luxury for the wealthy or the reckless. But here is what makes this truly alarming. The people making the most consequential decisions in American criminal justice are not judges or juries. They are prosecutors operating with almost no oversight. But that is not even the worst part. Pay attention because this changes everything. Prosecutors can charge whatever they want, stack charges to maximize pressure, and threaten maximum sentences knowing they will never have to prove anything in court. A defendant accused of one crime can face 10 charges overnight. Each charge multiplies potential prison time. Suddenly a 5-year case becomes a 50-year case. And the only way out is accepting whatever deal the prosecutor offers. This is not an accident. This is strategy. And if you want to see how this system actually breaks people, subscribe now because we are about to examine the cases that expose exactly how far this goes. Defense attorneys have a name for this practice. They call it charge stacking. And it has become the most powerful weapon in the prosecutorial arsenal. Now I need you to understand something most people miss. The Sixth Amendment guarantees the right to a speedy and public trial by an impartial jury. It is not optional. It is not aspirational. It is constitutional bedrock. Yet when 95% of cases never see a jury, that right exists only on paper. Legal scholars are now calling this a constitutional crisis hiding in plain sight. Former federal judge Jed Rakoff wrote that plea bargaining has become so dominant that the trial has become a luxury. The system has evolved to make exercising constitutional rights functionally impossible for most defendants. And the people trapped in this system disproportionately come from communities without resources to fight back. Tell me in the comments, did you know it was this broken? So here is the truth prosecutors do not want you to understand. The entire criminal justice system would collapse if defendants exercised their right to trial. Studies show that if just 10% more defendants demanded trials, courts would be overwhelmed within weeks. The system only functions because people give up their rights. This is not justice. This is volume management disguised as justice. And every time someone pleads guilty because fighting is too risky, the system grows stronger. Every time an innocent person accepts years in prison to avoid decades, the message spreads. Do not fight. Take the deal. Stay quiet. This is how constitutional rights die. Not with dramatic legislation, but with quiet surrender in interrogation rooms and courtrooms across America every single day. The plea bargain crisis is not a bug in American justice. It is the feature that keeps the entire machine running. Reformers have proposed solutions. Mandatory open file discovery so defendants actually see the evidence. Caps on trial penalties. Required judicial review of plea agreements. Massive investment in public defense. But here is the uncomfortable reality. Reform requires political will. And most voters never think about this until someone they love gets caught in the system. Until that day, it remains invisible. The 95% statistic is not just a number. It represents millions of people who surrendered their constitutional rights because fighting was too dangerous. Now you know the truth. The question is what happens next. Now you understand what 95% really means. Subscribe for more investigations into how the legal system actually works versus how it is supposed to work. I want to know your verdict. Is the plea bargain system justice or coercion? Tell me in the comments. And if someone you know is facing this choice, share this